What's up, guys? Brian Fell Law Group PLLC with your Florida Law Weekly case update. Hope everybody had a wonderful Thanksgiving. If you traveled internationally for Thanksgiving, I think you're really going to like this week's first two cases. They both have international elements to them. Super interesting. So the first one is Bravo versus Johnson. This is a case from Australia. The parties are Australian, and at some point they had a final judgment in Australia for child custody, child support. The judgment in Australia actually said that the father did not have to pay any child support because the mom, the father agreed to allow the mom and the daughter to move over here to the United States. They were supposed to move to North Carolina, which they did, but then, unbeknownst to the father, the mom and the daughter moved down here to Florida at some point. So the father got wind of this, and he filed an action in Florida under the UCCJA to enforce the child custody time sharing provisions of the agreement and the final judgment. So what did mom do? She turns around and files an action to modify child support, saying, hey, father hasn't been exercising his time sharing, so you need to modify the child support. So although the court had the ability under the UCCJA to enforce the child custody provisions, the court lacked jurisdiction to modify child support. Why? Well, first of all, Australia is not a member of the Convention on the International Recovery of Child Support and other forms of family maintenance. This is a convention, a treaty essentially, that allows for modification of child support under certain circumstances. And Australia is not a member of this convention. So under UIFSA, which is the Uniform Interstate Family Support Act, that's the United States version of what governs jurisdiction to modify. The Australian court never said, hey, we no longer have jurisdiction. They never relinquished jurisdiction, and they still had jurisdiction. So they didn't refuse jurisdiction, and they still actually had jurisdiction to modify the child support order. So because of that, the Florida court under UIFSA does not have jurisdiction to modify child support. So even though the father filed an action to enforce child custody under the UCCJA, the court did have jurisdiction to do that, did not have jurisdiction to modify the child support. So you're going to have sort of two different courts deciding these two different issues. Next case is a Hague Convention case, and this one is out of the 60 CA. This is De La Melena versus Panez, and this is a Hague Convention case. I don't know if anybody knows about the Hague Convention, but basically it was a convention that dealt with child kidnapping. It's really intended to prevent child kidnapping. And what it does is it establishes a home state for the child and says that child custody determinations should be determined in the child's home state. And so it allows for the child to be brought back to whatever the home state, the home country of the child is. So in this case, the parties were from Peru. Mom and the child move over here to the United States. They move into the Orlando area. The father actually allowed them to do that. He signed a waiver essentially allowing the mom and the daughter to come over here temporarily. It was only supposed to be a temporary thing, and then she was supposed to go back to Peru within a year, basically, not more than a year. So what happened? Well, the mom and the child, I guess they really liked it here in Florida, so they decided to stay. So they overstayed the time period that the father agreed to. Unfortunately for the father, he then waited over a year to try to file his petition and try to get the child back to Peru. By doing that, he opened himself up to a couple exceptions. Remember, the general rule is take the child back to their home country, let the home country determine the child custody rights in the home country. But there are exceptions, two of which applied here. First one is the well-settled exception. Basically, it says, well, if the child has been living here for over a year and the child is essentially well settled, and they list several factors determine whether a child is well settled in the new country. Child's age, stability of the child's residence, whether the child consistently attended school, his participation in extracurricular community activities, the mother's employment, financial stability, the child's relationship with family and friends, and the immigration status of the mom and the child. Those are the factors for the well-settled exception. So that was one exception. The court found that 5 out of those 7 factors favored finding for that the child was well settled here in Florida. So that was an exception. It's like an affirmative defense to the Hague Convention, the normal part of the Hague Convention. The other exception is the mature child exception, and that there's really no definition of what is a mature child. But essentially, if the court finds that the mature child exception applies, it finds that the child is mature enough to make a decision, the child can essentially object to going back to their home country. The child here was 10 years old, and so the court said the child was intelligent, even-handed, self-motivated, able to express her feelings clearly, perform well in school, had strong bonds with friends and classmates, showed no signs of depression, did not vilify or disparage the father, and the mother had not alienated her from the father. So basically, the trial court said, okay, the child is of a sufficient maturity to allow her to make a decision on her own. Hey, I don't want to go back to Peru. So for those two exceptions, the trial court decided to not apply the Hague Convention rule to bring the child back to the home country, and said, hey, the exceptions apply, and so the child was able to stay here in Florida. So that's good for the mom and the child, but bad for the father. The last case is not an international case. I just thought it was interesting. It dealt with a bunch of different issues. This is Rojas versus ISIS Pelaez, Otero. It's out of the 3rd DCA. But basically, the thing that I thought was interesting was a lot of times in our final judgments, we include language reserving jurisdiction, right? And so this was a case where the court said, no, you can't do that. You can't insert language in the final judgment reserving jurisdiction for certain things. For example, in this case, the court reserved jurisdiction over the parties and the subject matter to resolve all issues relating to enforcement of the provisions of the final judgment and to provide such other and further relief as the court may deem necessary. Court also reserved jurisdiction to modify and enforce this final judgment. So that sounds like language a lot of people kind of include sometimes in those final judgments, but you really shouldn't include it because it basically gives the trial court continuing jurisdiction to modify the final judgment. Only certain things are modifiable, right? I mean, only under certain circumstances, alimony, child support, child time sharing, things like that. They are modifiable. We have to file a supplemental petition, etc. But the court cannot just have blanket reservation of jurisdiction to enforce and modify. The court can't just reserve jurisdiction to resolve all issues related to enforcement because it's too broad and doesn't provide the finality that a final judgment is supposed to have. It's supposed to be a final judgment means something, right? It's a final judgment. So you can't include certain language reserving jurisdiction that gives the trial court more stuff to do because otherwise then it's not really a final judgment. It's inappropriate. So that's it for this week. I got a new slogan I'm going to start implementing. Fell out of love, call Fell Law Group. All right, guys. See you next time. Take care.